Okay, I want to touch it. I'm kind of just thinking about this little topic about a trust, and then my mind kind of going a mile a minute. So I want to kind of talk, speak on like an epiphany that's kind of running around in my head. But just basically want to talk a little bit more about trust, and how the truth is like everything is operating as a trust. Like everything is a trust. Everything is. And, just like a business, it's like we know our names are business entities, everything is operating based on trust. Everything. Um, you got people, when it comes, I'm trying to think of where to start when it comes to this topic. You got, say, Walmart, for example. It's a business entity created by Sam Walton, the grantor. Trustees are the people who run the business, you know. Maybe it started with him, maybe his sons, his children, or whatever, or whoever he started it with. I don't know the history, but just kind of using an example. And then, he might have made his children beneficiaries. So when he's dead, the business continues going and it continues going on even after his death. But it still is a trust. Okay? It's like your name, You're conducting business with that name. We've been doing it all our lives, all our adult lives. We've been just conducting business with that name. It's a business entity. But until we took control of it, if you look at the definition, gosh, I wish I knew it by heart. I want to say it is 26 CFR. 363.6 or something like that. Anyway, the definition of a minor. It's not just someone who's under the age of 18, but it's also someone who's attained the age of 18 but has yet to take control of the securities in their minor account. Now, I was going back looking at this. No, I'm jumping ahead of myself. Let's stay with this for a minute. When it comes to a trust, you have a business, you have your name, you're the grantor, the state of is the grantor. When you become and you are the beneficiary, the trustees are the ones that are actually running it, controlling it while you're a minor, including your mom, they may have them as well. Your mother's supposed to be like the, what they call the informant, but she's the custodian. But the trustees are the public officials, okay? Trustees are the public officials. And, when you become of age, reach to the age of 18, you just never took control of that name. You never took control of it. You just continued on, not knowing how to operate using that trust. You're supposed to take control of it. Not own it, but take control of it. Remember the saying, own nothing but control everything. And that's exactly what we're supposed to be doing. But meanwhile, you're still operating as a minor. You never took control of it. So you're still operating as a beneficiary. You can do that if you just know what you're doing. But you got to know who you are in relation to that name. That name is still a trust. It's just part of everything, included in that trust is the estate. Everything, all of it is the estate. And I guess I want to jump off into the presumption of death. And you look up presumption of death in each one of in your state. It don't matter what state you look up. I done looked up majority of them. There's this thing called a presumption of death, where you can see like a missing person, someone that's lost at sea or just kind of being presumed to be missing for at least 7 years. That's like the general number, 7 years. Some states is 5 years. 5 years. Here in Georgia, it's 4 years. They're presumed dead. Now we're talking civil death. We're not talking about an actual physical death, but civilly on the record, you're dead civilly. Which would, to me, explain why you receive a summons in the mail or you receive summons to come to court, because you can only summons the dead. Okay. So you walking in there as a dead man, or civilly dead man, that is, or civilly dead woman. You may be physically alive, but on paper, in their records, you're dead, which is why the judge, that's what gives the judge the presumption that, he or she can operate as executive over your estate. Because an executive can only administer the estate of a dead man or a dead woman, someone who's dead. But if you look into your state codes, look in there, you'll find it. Well, once it's been proven that you're not dead, then they have to cease from administering your estate and they lose all their power. So it's your job to prove that you're not dead civilly, okay? Because you walking in there as all caps name, and that's why the name in all caps is on your going to be on your tombstone. It's going to be in all caps. Civil death. But I guess that's where the civil and the physical death actually become one and the same once you actually do die. But you look at it, you have to prove that you're not civilly dead. Easiest way to do that is with a trust. Create a revocable living trust. Look in your state statutes. Just look this stuff up, y'all. Look this stuff up in your statutes. People tell you not to use your damn statutes because they say that applies to the straw man. Well, show me a straw man that can read a damn statute, and then we can go from there. But go ahead and look it up, and you'll see where it says that once it's been proven with a preponderance of evidence that that you're not dead, you're not missing, you're not dead, then all administration has to stop. It has to cease. I'm going to post a video that I actually did back in 2020. Disregard the disclaimer that I said at the beginning of that video. I might just edit it because in the beginning of that video I said I wasn't going to get back on YouTube, but I think I am now. But I just know it ain't but so much I'm going to say. But if you're doing some studying, you can see what the hell I'm talking about. But you study, look up the state statutes. It's telling you how to play the game. All the state statutes, they tell you how to play the game. They might word it a certain way, but they're still telling you how to play the game. And for years, I ran from the statutes because I used to hear on the internet some of these so-called gurus telling you not to read the statutes. We don't use the statutes. You don't want to quote them in your paperwork. You can quote them, but don't reference it. Don't write it, the codes down in your paperwork. But you can quote it. Just don't write don't write the code down. Don't write the, because you're trying to apply the principle without actually writing down where you got it from. Okay. So that's what I would advise in your paperwork. But, because the principles, they tell you how to, what should be in your trust. You should create a trust. Create your trust. A revocable living trust. It could be revocable or irrevocable, whichever one you choose to do. I prefer revocable because you can make changes with a revocable living trust. But irrevocable, it can't be changed. But you also see in there that in all your state statutes, you look it up now. Look this shit up now. Prove me wrong. When you look it up in your state statute, it's going to show you that what governs a trust is equity and common law. Common law and equity is what governs a trust. And we know equity and common law deals with living men and women. If that's not rebutting the presumption of death, what is? So you might want to look that up. Get off into looking into trust law. Trust law is something I should have been looking into a long time ago. But I'm not gonna go off into the mechanics of it because if you're a reader, you'll find the shit. I'm telling you where to go look. Look in your state statutes about revocable living trust, presumption of death, and you'll see exactly where your power is at. Creating a trust, it tells you what needs to be in your trust. What needs to be in there. And it goes even deeper than that. There's a hell of a lot of things you can do with your trust once you get one created. Once you create one, people will tell you, record your trust in the county, on the records or whatever. Keep in mind, a trust is private. The mechanics of your trust are not supposed to be recorded. If you want to do that, go ahead and do it. It's totally up to you. But it never said in the state statute you're supposed to record your trust. It's private. Some people record them inside the court case. That's totally up to you. I ain't gonna do it. Keep in mind in your state statutes, another thing put on your list, you'll find on there, it tells you, look up in your state statutes, certification of trust, certificate of trust. Type certificate of trust in your state in there, and you'll find the code is going to tell you what needs to be on there. That's what's supposed to be recorded. You record that trust, record that certificate of trust. When you record that, that's what you're going to use as your evidence that the trust actually exists. You don't leave the trust just sitting on your bedroom counter, on your dresser, saying, it's private, and you don't want nobody to know you got a trust. Yet you want somebody to expect you, to move forward as if you got one, because it's private. No, you're supposed to let them know the trust exists. But that's what the certificate of trust is for. It tells you how to make it, how to create it. It ain't no certain lingo. It's not a certain language you have to use. It tells you you don't have to use legalese to create one. So you ain't got to worry about trying to, learn all. You don't have to do all the extra shit. Okay, this is for living men and women. It's not for somebody. You don't have to, learn all this different language that they speak in the court. You create it how you want it, as long as it has those basic requirements of a trust in there, then it's going to work. It's going to work. Have your grantor, the trustee. You can have more than one trustee if you want to. I would. And your beneficiaries, whoever you want to be your beneficiary, it's totally up to you. But you create a trust. I wouldn't recommend creating a trust and naming it the same thing as a straw man. I just wouldn't even use any name in the straw man. That's just me. I want to have his own identity. And then you go from that point. They got all types of templates online. Revocable living trust, revocable, irrevocable. They got all types of trust templates online. You don't even have to do a whole lot of writing if you don't want to. It's up to you how you do it. But you have to create a trust. If you want to, that's one way, one of many ways you can actually rebut that presumption of death and take away the power of the courts from running one in you dry. So look off into this. Look off into a trust. Get your trust and create that thing. Get your certificate of trust. Hook it up. Get the certificate recorded, and you can get a certified copy of that certificate, and you can move privately with the judge with that certificate. Okay, of course you gotta serve all parties, opposing party, the judge. With your document, whatever your demand or whatever, your notice and demand or whatever you're gonna put with that certificate. However you're gonna execute it, but you're gonna have to deal with that judge on the private side. Without you can put the certificate of trust in the court case if you want to. That's totally up to you, but you can do that if you want to. But I wouldn't put the trust in the court case. Now, I'm not known for people to do that and get remedy, but you don't. Most people maybe do the first and last page or something like that, so they don't have the mechanics of the trust in the court case. They may like excerpts from the few pages from the trust and file that in the case, not the entire trust. But it's up to you how you do it. But you definitely rebutting the presumption of death and can shut the case down. I literally spoke to a guy. I'm not gonna say his name on here because he may not want me to know all that. Well, he might not want me to say all that. But he's married and he was serving some time in jail, looking at some serious ass time for some gun charges. Plus he was on child support, $30,000 behind in the rears. And him being locked up, his wife found this remedy with these people and actually part of it. They did a number of things, and she paid for the remedy, and part of that remedy was a living trust. It was a revocable living trust, and got him out of jail. He literally called me and told me his testimony, and it got me on fire because it let me know I'm on the right path with what I'm doing because I'm dealing with a revocable living trust. I ain't in jail. Ain't looking at no felony charge, no charges or nothing like that, but. At the same time, that was powerful as hell for him to be able to get that done and get out of jail and get free. It even cleaned everything off of his credit that was in his name. With the exception of one thing that's in him and his wife's name. She's the primary person on the account. That's why it didn't clear it out. But it cleaned his credit up, threw the case out, dismissed the case, the child support case, the gun charge case. It killed everything. So, revocable living trust is what he used. I'm gonna use a revocable too, so you can make it revocable or irrevocable, however you want to do it. But you definitely want to get you a trust. Get your goddamn trust, man, and watch how shit get shook. Okay, but I ain't gonna say too much because it's a whole lot of things you can do with a trust. But I'm not gonna say all that. I'm learning them more things. The more I'm learning, there's some things I can't say. I just wouldn't say it online because everybody don't need to know all that shit. You know what I'm saying? And I'm going to leave that like that. But I'm going to go on and sign on off of here because this video is long enough. I thought I'd go ahead and vent because my wheels are turning. You're rebutting the presumption of death. You're shutting down the case because you're no longer presumed to be dead. Civilly dead, that is. And you have proof on the record that you're not civilly dead because there's a trust put in place. A living trust, revocable living trust. You got the witnesses on there. There's a maxim of law that says every word shall be established from the testimony of two or more witnesses. I'm paraphrasing, but that's a maxim of law, and it's also Bible scripture. And we know Bible scripture is part of law as well. And it's the law of the living. The scriptures are law. That's the law of the living, not the dead. Okay? So You got that on the record. It's recorded in their records. It's a prima facie evidence. It rebuts the presumption. That's simple. And anyway, I'm just ranting now. But I'm going to get on off of here now, y'all. So hopefully y'all take heed to what I'm saying and go ahead and look up what I'm saying. So prove me wrong. Just go look the shit up. I know what I'm talking about. All right, y'all. M. Rose getting up off of here. Signing out.